Hello, everyone. Look who is back here, Barrister Yolanda. Ooh. Barrister Yolanda, for those that missed part one, please, can you introduce yourself?
This is Barrister Yolanda, the principal partner of the law firm, engaged in legal services like recovery, incorporation, dissolution, core litigation.
CCV now.
We're not just on retainer with, small minorities. We're on retainer with various top banks, the likes of Sterling, Fidelity, Zenith, FCMB, and other private companies. I don't want to be out there, but yeah.
You do registration of companies, right?
Oh yeah, we do registration of companies. We do increase, anything that has to do with your company. You want to wind up your company, we handle that. You want to open a new company, we handle that. You want a business name registration, we do that. You want to increase share capital, we do that. You want a letter of good standing, we handle that too.
So if you need any of these services, Yolanda's contact information will be in the description box below. So let's get ahead with it. This is part 2. We did a part 1 video where we answered so many questions, all the burning questions from tenants. Okay. Today we're answering questions from the landlords. And let's start with the big elephant in the room. Who is a landlord?
A landlord is the owner of a property. Emphasis on the owner. A landlord is the owner of a property who decides that after slaving and building has decided to let it out to an individual to handle with care. That is a landlord.
There's a specific question here about a tenant that is living in a property owned by 2 brothers. So some of the tenants pay rent to one of the brothers, the other tenants pay to the other brother. So sadly, one of the brothers died. So this tenant is asking, who is now her landlord? Is it the wife of the man that died or his brother?
Listen, this is a family matter. Don't get yourself involved. Pay to the wife. The wife is who naturally takes over from the deceased. So pay to the wife. Because you have a tenancy agreement with the person that is deceased, your landlord that has already passed. And naturally, the wife takes over. So until this resolve your family matter in court, please pay your rent to the wife.
Is there any way to tell who will be a bad tenant during the screening process?
Oh, come on. There's no way. There's really no way. But we try. You can try to ascertain it by the occupation the individual is into, character, looks. I know some landlords go as far as asking what caused your previous breakup in your relationship, to know if you're a violent person and all of that.
Really?
But that's just they ask crazy questions. You see, I look at I'll see some tenancy interviews where the lawyer has to or the landlord has to interface with the tenants and asking them personal questions. They're asking those personal questions in all sincerity to avoid any future issues. They don't want to have issues with the tenant about paying your rent, or about you turning their house into a clubhouse, or about you destroying their property, or about you fighting and causing issues in the compound. You have tenants that refuse to pay service charges. You have tenants that refuse to pay the cleaner's fee. So that's why they ask these questions. If a landlord tells you, I'm not going to let out my house to you if you're single, they have their reasons. They've probably experienced bad. I'm not going to rent my house to you if you're not having a proper job. They have their reasons. They have bad experiences. So when they ask those questions, they ask deep questions like, what's your job description? They want to see your ID card showing it. They want to know if you're a family man, or if you're a single man or a single woman.
Wow.
It's okay. They can ask as much questions as they can.
That's actually my next question, because I was going to ask you if, as a landlord, I have a right to reject tenants based on their marital status, tribe, religion, economic status.
YES. Wow. Yes.
Wow.
Do what works for you. If you're a landlord, you're looking at the tribal issues. It's your property. You know what you had in mind when you went to go and build, right? No one is going to force you. You do not slave all the while for someone to come and detect you who will stay in your house and who will not.
Wow.
So there's no law against tribe, you not accepting a tenant based on the tribe or based on the job description or based on the personality issues. That's you doing your own due diligence. Now, if you think those things are what will help you, enable you pick the right tenant, do so. But don't forget, people can pretend. Don't forget, you can really not get who an individual is just by meeting them one-on-one. Change is constant. But do as much as you can or you want to if it helps you to sort out your tenant. Or get your lawyer to do that for you.
So that brings me to the next question. How much information can I actually request of a tenant? We know the usual suspects. We need your name, your phone number, email address, your place of work. But can I also ask for the person's name?
The name is your ID card.
Because a lot of Nigerians think NIN is private.
Oh, come on, it's not your BVN.
Okay, so
NIN
BVN is private.
BVN is private.
But
no one is asking you for BVN. You're on your own. Don't release your BVN to your landlord or to anybody. But your NIN it's not private.
An ID.
It's your ID card.
Can I ask for work ID as well?
Yes, please. You can ask for your name and you can also ask for your work ID.
Wow.
NIN is to ensure that the name is actually for the person. And you know some people tech these days, you can just formulate a work ID just for a different purpose.
Can be
So you can see that the name on the ID is different from the name on the name. So just for due diligence and further verification, they can ask you for your name, which will show your actual name, and then your work ID, which actually shows that you are working somewhere and you're using the right ID card.
A big one, caution deposit. Is there a fixed rate for caution deposit? A property manager once told me that it is a percentage of the rent, which does not make sense to me. I feel that it should be based on the value of the fittings in the apartment. So what does the law say about this?
There's no law on caution deposit. You cannot predict how much someone is going to, are you going to predict the wear and tear that can happen in your property? It's not predictable. You might come in, there is nothing for you to actually amend that is major. You might come in, there are things way above. So caution deposit is at the discretion of the landlord. What do I think this fitting is worth? What do I think if it's destroyed? How much am I going to spend to fix it? That is what caution is, to take care of the wear and tear, whatever damages you leave in the apartment when you're stepping out. So there's nothing fixed on it. Whether it's a percentage, there's nothing fixed on it. What do I think is good to take care of this damage if it's caused?
Okay, that's good to know because I don't want to start. As a landlord then, can I inspect my apartments from time to time? I mean, inside the rooms, toilets, kitchens, so that I'll keep an eye on some tenants because some of them, by the time they move out, they've trashed the whole apartment. Yeah. So can I conduct inspections?
Of course, you can. It's your right. But please, let it be a clause in your tenancy agreement. Let the tenant be aware that in 3 months or every 6 months, I will come and do a check. I will come and do inspection. Let the tenant be aware. Don't just barge in. You're the landlord, you're the owner of the property, it's fine. But tenants also have their rights. Okay. And they're also paying for that right. So please, you can inspect your property at any time, but let it be discussed with the tenant. Let the tenant be aware. And just for clarity purposes, ensure that it is enclosed in your tenancy agreement. Let there be a clause that states it that every 6 months, every 3 months, every month.
So however often I want.
But let it be discussed. Let the tenant be aware that you signed an agreement to allow me into my property to do an inspection as at this time. So every month, the 30th of January, I'm going to be coming for an inspection.
Wow.
Every May I'll come. Every 6 months I'll come. But let it be enclosed in your tenancy agreement.
This is very good to know. This is good to know because I always felt that these are adults. This is not a dormitory. It always felt, makes me uncomfortable having to go and inspect adults, you know.
Yeah,
But
yeah. You know, it's
good to know.
Yeah, you know, if you barge in, you're encroaching on their fundamental rights to peaceable enjoyment. You know, so don't barge in. Make sure it's in the tenancy agreement. So if at some point they claim that you have encroached in their fundamental rights of peaceable enjoyment, you refer them to the tenancy agreement that they signed, even though tenants don't read the agreement.
Assuming that this clause is
Yeah.
not in the original agreement, you know,
Yeah.
we are all learning every day,
Yeah.
right? So
Yeah.
can I write a new agreement to existing tenants?
To existing tenants, it's a bit tricky. You can write a new agreement for a renewal when the tenants wants to renew.
Oh, their rent, right?
Yes, when they want to renew their rent. If a tenant wants to renew their rent, always give them a new tenancy agreement. Give them a new tenancy agreement. Because if you now have new things you want to put in tenancy agreement that is not in the previous one,
You get them
before
to sign it.
yes, before the tenant renews the rent, give them another tenancy agreement.
Good.
But don't ask them to pay agency fee again because they are renewing.
No, not agency, legal fee.
Yeah, legal
Because
fee.
agency
But it can
fee,
be
they're not-
subsidized.
Okay.
It can be subsidized because it's the same tenant. It's a continuing
Okay.
tenant.
If the lawyers, if you guys will agree now, will you guys subsidize?
Subsidized.
So now, what do I do when a tenant destroys more fittings than his or her caution deposit can cover? I mean, the tenant has moved out. The only thing we have on the tenant is the phone number, their name, their email address. How can we find this tenant to bill them?
Okay, so I can advise two things. You can either call it a loss and let it go, or you can file a process in court for damages, claiming damages against the tenant. Now, if you don't have any further details about the tenant, you have a phone number that they registered for, the normal form they fill before they come in. You have a phone number. We can use that in court to file a motion for substituted service. I digress. Now, substituted service is where you don't have the known address of the individual, but you have the email or you have the phone number, and then you decide to apply for a motion of substituted service to serve that person the court processes via phone number or email.
Wow,
So
that's
that is
great.
deemed as proper service.
Okay,
Yeah.
that's good. What if they don't acknowledge seeing
Oh
that?
no, so long as you show that you serve them via the known phone number and an existing email, that suffices.
it.
Yes.
Okay.
That suffices.
That brings us to another big one. Can I, as a landlord, dictate how much letting agents I work with should collect from prospective tenants?
Oh God. Yes. And I think with the way it currently is right now in the country, every landlord should please pay attention to whatever fee an agent is imposing on a tenant. It's getting crazy these days. So as a landlord, you have a right to discuss with your agent. I'm going to give you a fraction. I'm going to give you a percentage. I'm going to give you 100,000, 50,000 if you get someone to if you let out this property to someone. It's decision. It's at the discretion of the landlord. It's your property. So yes, there can be negotiation basis. The agent can tell you, oh, I won't do 5%. I will do 3%. Well, I won't do 3%. The landlord can say, I will give you 100,000 if you rent it out. I will give you 200,000 if you rent it out. But please, landlords, put your eye into whatever an agent is collecting. And most agents are really, 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 we have some agents doing the good work, but we have some that are just extorting tenants.
Shylock agents.
They're just extorting tenants. So yes, the landlord can actually decide on what amount an agent should charge.
Now, eviction, the one that leaves a sour taste on the mouths of both landlords and tenants. Nobody wants to go through this. So, please, can you give us a step-by-step eviction process? We're all ears, please.
Oof. I think this is the major question. So, if your rent expires, you're no longer a tenant. There's no agreement binding you and the landlord, right? But then you're entitled to just 7 days notice for the owner to recover possession. Now, because people think 6 months notice is actually after your rent has expired, you're entitled to stay in the person's house for 6 months. No, please be aware that 6 months notice is given pending your tenancy.
While your tenancy is still running.
While your tenancy is still existing, that's when you get the 6 months notice. It's supposed, and yes, the 6 months notice should expire the eve before your tenement, before your tenancy, right? That's when the 6 months notice should expire. Example, your rent expires November 30th, right? They're giving you quick notice. It should be, is it November, October, September, August, July, June. So if you're going to be served the 6 months notice, your 6 months notice should come in June.
Before your rent expires.
To expire the 29th of November. The eve of your tenancy. Yes. So that's the 6 months notice rule. Please, you're not entitled to 6 months notice
free
after your rent has expired. This cannot be emphasized enough. You're not entitled to 6 months after your rent has expired. And even if you stay in the property for more than your rent has expired, you are going to pay. Except there is an agreement with you and the landlord to stay for a certain period of time, and then you leave. It's at the landlord's discretion for you to stay. Don't think any court is going to say you should stay in someone's house for free.
No.
Don't be deceived. Do not be deceived.
Thank you so much. Thank you so much for explaining that in details. Because
And the usual way is 6 months notice. After it expires, 7 days owner's intention to recover possession. If you're still in the building, then a court.
They go to court.
Yes.
Talking about court, that's the most frustrating part of this eviction process. How long does the court proceeding take normally? Normal duration?
Depends. It's not predictable. It depends. I have done tenancy matter in 3 months. It ended in 3 months. I've done tenancy matter for 6 months. I'm currently on one which is staying close to a year. So please, it all depends. We don't know the mind of the magistrates. We have a very tight judicial system which does not give us room for shorter dates. So you might be lucky enough to get, adjourned dates for 2 months, a month, 2 weeks. It all depends. I mean, it's not predictable.
And what betide you if it falls when they are going for their annual break?
They're going for break. Sorry.
So as a landlord, can I issue a notice to quit myself, or must I use a lawyer?
Oh no, you can't issue a notice to quit yourself. Nowhere in the law says a lawyer should do that. But a lawyer should do it because of the essentials that should be in a notice to quit. So you can issue a notice to quit yourself, but get a lawyer to vet it. There's some details that you will miss out on if you issue it yourself. There's some things you might be ignorant to that the lawyer will not be ignorant to. And once your notice to quit is not properly issued, then it's defective. It doesn't stand. So get a lawyer to do the needful.
But what are the key contents of a notice to quit anyway?
Okay, the address of the property, the actual name of the tenant occupying the property, that is the name in the agreement of the person occupying the property, the description of the property. Is it a 3-bedroom? Is it a duplex? Is it a bungalow? Is it a mini flat? Then the date, of course, you date your letter. Then the date for the expiration. That's the notice. Very, very important. Once your notice is defective, it is not enforceable. It's void. So get a lawyer, because that way he or she would know how to count the days to know it should expire the eve before your tenancy expires and whatnot. That's why it's necessary.
Okay. Meet the experts. We've already established that a notice to quit is 6 months.
Okay.
But as a landlord, can I issue a notice to quit at any time? Maybe I want to give the tenant longer period to find a new place. Maybe the tenant renews his or her rent today. Can I issue a notice to quit the next day?
Listen, you can be handing a tenancy agreement and be handing the tenant a notice to quit.
Wow.
There's nothing against issuing a notice to quit. Just don't let it be shorter than the prescribed time in law.
Yeah.
So it could be more, it could be 8 months, it could be 6 months, but is it below the 6 months or the required time for the notice, or is it above?
Yeah.
So you can issue it at any time, but let it be within the time frame that the law has given to you.
Yeah. There's a specific question here about somebody that has 18 tenants.
Okay.
And he said that the house needs urgent. The tenants are owing rent, which means they're not even legal anymore.
Okay.
And he wants them to leave the premises for renovation. That the house is in dire need of renovation. So,
Okay.
what does he do in this case?
Okay, well, first of all, it is important, and the law clearly states that a property should be in habitable place for the tenants. So for individuals, it should be habitable. Now, if you think that this property needs serious or dire renovations, as you say, issue them 7 days notices. No one there is entitled to 6 months notice. All of them there are no longer under any tenancy agreement. So they're now all tenants at will. Now, tenants at will are just issued they ought to be given just 7 days notice. Now, when you give them the 7 days notice and they don't leave, you commence an action against them. But please have the proof that the property needs to be renovated. If it's a broken fence, if it's a leaking roof, if it's something major, if it's a gutter, if it's a falling tiles, have pictures to show the court that this thing needs their repairs. But we can't do that. You can't achieve that because the tenants have refused to leave the property.
What if I issued a quit notice on time, but the tenant refuses to vacate the property at the end of the tenancy? Can I throw the person out?
Hey, please,
Hey.
please, I beg you, as a landlord, never ever resort to self-help. Never ever. Don't think because you're the owner of a property, you will just go into the tenant's house and throw their bag. No, please. If you come to me with that, I will fight you personally. Do not resort to self-help. The law is against self-help, and the law is majorly on the side of the tenants. So please do not throw out the tenant's property. Get a lawyer and go to court. Get me and resolve it. As a tenant, if your landlord resorts to self-help, call me.
Call
me.
Barrister Yolanda to come
Call
and make you
me.
some cool banana.
Let's resolve it. Call me. If your landlord comes to your house with boys or police, even the police doesn't have a right to throw you out of the house, except it's with a court order. But if your landlord does that, call me.
So is this the worst sin of a landlord then?
This is the worst thing. Landlords, please do not resort to self-help. No matter how angry you are, no matter how pained you are, do not resort to self-help, because a tenant can claim anything against you. They can claim when you came to throw out her bags, you left $1,000, she left $24,000 in her bag, and she can't find
Exactly.
it. Oh, you spot a MacBook Pro laptop, 2025 edition.
Oh my
Please.
God.
And you will pay because you have no room, you have nothing to show that you did not destroy those things. You cannot prove that you did not steal the money, but she can prove that you barged into her house and you threw out her stuff.
So anything you see from that, you take, right?
I think this is the part where I'm on the side of tenants. Tenants, don't forget, if your landlord does that, call me.
You know who to call.
You know who to go.
If I win a case against a tenant, how can I recover the accrued unpaid rent while the court case was going on?
Before we get into that, have you liked?
Ah.
Have you commented?
Have
Are
you
you
subscribed?
subscribed?
Have you watched part 1?
Have you watched part 1? So that we don't have to do this again. So that we're clear. So that you don't come for me.
Barrister Yolanda will take you to court too.
Like, share, comment, subscribe. So yeah, if your tenant is in arrears and the tenant has left the property and you need to recover your money, we can do what we call garnishing. So garnishing is putting notice to all the banks in Nigeria. Of course, you put notice to all the banks in Nigeria, letting them know that, you know, they should come and show cause in court that this individual has an account with them and this is the amount of money in the account. So if the court gives an order to that, and they maybe, you know, garnishi UBA or garnishi Fidelity, when they garnishi all those banks and they come to show cause that yes, Ngozi has 20,000 naira in her account, Fidelity comes and says Ngozi has 200,000 naira in her account. If the money that the tenant is owing you is about 250 or 210 or whatever the tenant is owing you, and the banks come and show cause that yes, you're banking with them and this is the amount you have with them, there's a court order to release the amount to you. So that's how you get
The
your
money
money
back.
Yeah, even if the tenant runs away.
And this is for all the banks in Nigeria.
All the banks, OPay, even all the microfinance bank, Goldman, OPay, Rent Money, PalmPay, Money Point, all of them are not inclusive in Ganishi. They were not there initially, but now we have
Everybody's in there.
everybody's like
Landlords, have you heard? So be patient. Be patient. You'll get your money back.
You want to get your money? Call me.
What do I do if a tenant starts using my property for other purposes than the one stated in the tenancy agreement?
You can evict the tenant. Your tenancy agreement clearly states the purpose of possession. Now, if the tenant has refused to obey the rules or goes against the contract, that's a breach of contract. So you can either evict the tenant if it's something major or in the process of the tenant renting a place for commercial purposes. You can, claim damages against the tenant.
In the tenant's Q&A video, you said that landlords are responsible for major repairs.
Yeah.
Who is responsible for the repair of the water pump? Is it the tenant or the landlord?
When it comes to issues of water pump or the pumping machine, if the landlord wants to do that, he can handle it. But the tenants are supposed to do that because that pumping machine was in good shape when you came in. Now, it was probably the usage, it was probably the current, it's something that destroyed it. So why would you destroy something?
Yeah, that's the argument usually. If it's the current, the tenant can say, oh, it's not my fault, it's the current, it's a surge in current. So, but
No.
Are you saying that the repairs at all times should be borne by the tenant?
It should be. Communicate with your landlord. If your landlord wants, if he feels like it, he can say, okay, how much is the pumping machine? It's 100,000. I'll give 40,000 towards that.
Okay.
I'll give 50,000 towards that, towards the repair. But don't think the responsibility lies solely on your landlord.
What about evacuation of the septic waste?
Well, that should be the duty of the landlord.
Because it's part of the
Yes.
making the place.
Yes, it's supposed to be
Habitable.
habitable. Yes.
Okay.
So it's the duty of the landlord. I mean, no tenant wants to take over the duty of evacuation. It's your property, so it's the duty of the landlord.
That's
it.
everything. That's all the questions, man.
it.
So for all your, please, can you tell us your services again?
Okay. So I'm Barrister Yolanda, the principal partner of the Law Lane. It's a law firm that engages in the services of debt recovery, dissolution, core litigation, CAC, incorporation of companies. You want to wind up your company, you want to increase share capital, you want to do anything, partnership, incorporate, new registration, new company, call me. You want to dissolve your marriage, call me.
Oh my God.
You want to go to court, you want to recover your money that has been taken from you, you gave out a loan less than 5 million naira and you want to recover it. I handle that in 60 days. The court we have room for that.
Wow.
So long as it's a loan below 5 million naira, is resolved in 60 days. You get your judgment in 60 days. So yeah, that's it. We're on retainer with the various banks. We're on retainer with Sterling, the likes of Sterling, Fidelity, Zenith, currently FCMB, and other private companies.
Yeah.
I'm your go-to girl. Call me.